narrow issue which I canvassed was, my lord, the MSME Act and the notification cast a duty, statutory duty, to at least, my lord, constitute a committee and make it a reference to it when there is a default. And the law. Yes, yes.
Judicial application of mine is there, then thereafter review will not lie, because it says we do not find any case made out to infer that itself shows that there is an application of mine. The detailed order is not required under 130.
When it was dismissed?
It is dismissed just 3 days ago. On 9, 2 days. The submission, my friend should have made at least an oral submission that this was there.
But now my friend has raised that issue. Then I'll answer that issue.
So, counsel, when you started argument, you should have mentioned that I filed an SLP that ended in dismissal.
No, my lord, the all issue is...
That should have been your first submission.
No, my lord, now... No, my lord, that is of
this is not something which should be pointed out by the counsel on the other side.
No, my lord,
Yes.
my lord, that's a legal issue. The dismissal of an SLP, refusal to grant leave to
So,
appeal.
counsel, that is an entirely different aspect. But your submission, when you filed an SLP and it was dismissed on 9/7, your first submission today should be, I filed an SLP that ended in dismissal.
Well, I will certainly said, I have just started only.
No.
Now, the whole issue is, now
Yes.
my friend has said it, then the question is whether dismissal of an SLP in limine, with or without reasons, constitute an estoppel. The concept is, cause of action is, what is restitution? Cause of action is estoppel. Cause of action is a disputed reference. That Tolle versus Tolle not really has defined it. Cause of action is a disputed evidence. When it is subjected to a trial, it transforms, it undergoes a process and it transforms into something else. And that is called...
Whether we have a copy of this SLP?
I have a copy. I have a copy right here. So that is called the concept of transit in the judicial. Then the cause of action, which is a disputed evidence, when he found to be in existence, then if it is court holds me in my favor, then it comes to the doctrine of merger. Cause of action, when a court finds it in existence and gives a decree in my favor, the cause of action ceases to be in existence, it having merged with the decree of a court, that is called the doctrine of merger. And when a cause of action is found to be not in existence, then there is nothing to merge, there is no merger. But there is a concept of residuicata. When a court has said 1 plus 1 is 0, I am bound. It's manifestly wrong, I am bound. Now, therefore, the doctrine of...
You made certain submissions. Don't repeat the very same submission.
No, I am saying,
Yes.
and I am coming to this issue has been
You can
decided.
complete your submission.
No, this issue has whether dismissal of an SLP will constitute a merger or residuicate or bar was decided, is considered in at least 3 judgments of the Supreme Court. One is in Punjab from Kerala. And later, in the three judge of the Supreme Court in Justice Sikri's judgment in Korea Industry. And then this issue came before in one of the matters which I myself appeared, and this is Manisha Mehta versus and the Supreme Court, there the judgment was later, order was later, 15th of July 2024 by Justice Suryakant and Justice Suryakant and Justice Suryakant, and said that when the SLP is dismissed, it does not constitute a merger or residuicata, and a review petition. In that case, it was a review petition was filed subsequently. Here, a review petition has been filed immediately after the judgment was rendered. Therefore, the review petition will die. And I will place reliance on those judgments, the SIT judgments. This is fundamental. Nobody, the Punjagamad's case, Tode's case, Tode distilleries. I'll give the citation. I am giving the citation for this. Tode here. So therefore, there is no merger. Let me proceed with that. I have to give the citations. Yes. Yes. When I need only go into the answer the question of estoppel, which is absolutely not difficulty to answer. When that contention is raised, see, the doctrine of estoppel, the burden is on the one, on me, on them to establish it, but they raised it. So I accept it. And I rely on the judgment of the Supreme Court in Order Industries. Let's get that. What? Yes. Yes, equivalent citation is, yes. 2019 is Supreme Court cases, 2218. The bench of Justice Sikri, Justice Ammar Shah, and Justice Abdul Nasser. And the
That is a 2019 for CC3, sir.
yes. The principles have been reiterated in paragraph paragraph 27. From the cumulative readings of the various judgments, we sum up the legal position as under. The conclusions rendered by the three-judge bench of this court in Punjagamad's case and summed up in paragraph 44 are affirmed and reiterated. We reiterate the conclusions relevant for these cases as under. An order refusing special leave to appeal may be non-speaking order or a speaking one. In either case, it does not attract the doctrine of merger. An order refusing special leave to appeal does not stand substituted in place of the order under challenge. All that it means is that the court was not inclined to exercise its discretion so as to allow the appeal being filed. If the order refusing to leave to appeal is a speaking order, that is, give reasons for refusing to grant leave, then the order has two implications. First, the statement of law contained in the order is a declaration of law by the Supreme Court within the meaning of Article 141 of the Constitution. Secondly, other than the declaration of law, whatever is stated in the order are the findings recorded by the Supreme Court which would bind the parties thereto and also the court, the tribunal or authority in the proceedings subsequent thereto by way of judicial discipline. The Supreme Court being an apex court of the country. But this does not amount to saying that the order of the court or tribunal or authority below has stood merged in the order of the Supreme Court rejecting this specially petition, or that the order of the Supreme Court is the only order binding as res judicata in subsequent proceedings. Once the leave to appeal has been granted and the appellate jurisdiction of the Supreme Court has been invoked, the order passed in appeal would attract the doctrine of merger. The order may be reversal, modification, or merely affirmation. On an appeal having been preferred, or a petition seeking leave to appeal having been converted into an appeal before the Supreme Court, jurisdiction of the High Court, etc., to entertain a review petition is lost, thereafter as provided, etc. So, but on the question of the estoppel, res judicata, merger, all arises where the Supreme Court has considered the judgment of this court and for X or Y reasons either affirmed it or rejected it. So there is these are the fundamental principles of universal application. You know, the principle of res judicata, it is not an instrument to do justice. It is not an instrument to justify injustice. The only purpose of doctrine res judicata is interresto republico ut sit finit litium could be answered. So therefore, there is ought to be finality of litigation that is in public interest. And nemo debet bis vexari pro uno et idem cosa. No man shall be vexed on the same question more than once. So the whole concept of estoppel, there is a presumption of estoppel. Estoppel has to be pleaded, and there is no estoppel against law. So therefore, my lord, even if the judgment of the Supreme Court, even assuming that the Supreme Court has passed an order on merits, delving into every aspect of it, my lord, if it is a pure question of law, which as is in the present case, a new petition will lie. And my lord, I take your lordship to two judgments, only two judgments. That is of the 7th Constitutional Bench in Andule's case, and a short judgment of the hands of Justice Nariman. And Lord, I take your lordship to Justice Nariman because a brief judgment makes it easy for reference. Yes. So therefore, the concept is, my case is, as any layman can understand, it's very simple. There is an order of the Parliament. No bank shall classify an account of an MSME as NPA.
Mr.
Yes.
Nadambara, you need not raise your voice to this.
No. Everybody has.
You are using a mic.
I'm very soft.
You are using a mic.
Yes. Okay. No, fine.
Yes.
Everybody has his style. I'm most often I'm very soft, extremely soft. When I'm provoked only I say them.
Yes.
Otherwise I'm a very soft person. There are instances I am provoked I speak. That is the nature. Because
Make your submission.
Yes. Since your lordship, yes. Now I take your lordship to paragraph 34(2). Oh, sorry. Let's pass on. Paragraph 34(2). Yes. Paragraph 34(2) at page 260. An issue of law. Lordship, got the law? 34(2). An issue of law which arises between the same parties in a subsequent suit. Lordship, got the law?
34.
Page 260, paragraph 34, 2.2.
Yes.
An issue of law. An issue of law which arises between the same parties in a subsequent suit or proceedings is not res judicata if, by erroneous decision given on a statutory prohibition in the former suit or proceeding, the statutory prohibition is not to be given effect to. The earlier decision was that the mandate of the Parliament, an account of MSME shall not be classified as NPA without extending the benefit of the notification for the resolution of stress, nursing and care. That judgment cannot be given effect to
Which is that decision?
Hello?
No, which is that decision? Earlier decision was.
No, that is the judgment of the justice, the single judgment which was reaffirmed by your lordships. In this case, there is no previous decision even actually.
Yes, yes.
In the Krishnamar case, so all reference has been in this case is about Krishnamar. But the facts in the Krishnamar and this present case are entirely different. In the Krishnamar case, he came many times here. And in the case of SARFAESI also, they came 14 times there. So they came every time, and therefore the matter was considered many times. And therefore the court said, once a matter has been decided one way or other, it constitutes a res judicata. So in my case, in the present case, the res judicata means there should be a decision on merits, either on merits actually or constructively. Actually or constructively, not by implication. So there are only, my lord, 4 writ petitions which has been filed in this case. May I pass on this? One is 3873 of 2023. Yes, that is the judgment of the hands of Justice Devan Damian. This is Devan Damian. Dated 2nd of 27th of November 2023. That judgment, nothing has been decided. Only I have been last paragraph, page 4, in the above circumstances, leaving liberty to the petitioners to invoke every other remedy, meaning forum, every other remedy before the appropriate statutory forum, including the question of classification of the record as the and leaving open their contentions on the applicability of Exhibit P7, etc. in this regard. So that is a notification from the government and by the RPA. Nothing has been decided. Then, my lord, so there is res judicata means something has to be decided on the merits of the case. Second is of dated 24th of June 2024 by Justice Nagresh. There also, my lord, last, and I will not trouble your lordship by reading the judgment except the last paragraph at page 5. In the circumstances, lordship court, my lord, no relief can be granted the petitioner's pay for. The petition is, however, disposed of permitting the petitioner to prosecute the petitioner's remedy before the Statutory Tribunal. All discussion was about whether the avenue is open. Then, my lord, next petition which I filed in the Bombay High Court, that is disposed of 11th of December 2024. The lordship court, my lord, yes. It says, yes. The Kerala Council for the petitioner seeks to leave to withdraw the petition with the liberty to approach the Kerala High Court where the registered office of the respondent respondent National Bank is limited is located. The petition is permitted to be withdrawn with the aforesaid liberty. In case respondent number 3 desires to take any further steps to proceed against the secured asset, we shall give notice of 15 days to the petitioners. All points and merits are kept open. So the rest remains sub judice. There is no res judicata. Then comes the judgment of the Justice Gopinath. And there I take your lordship. There was no contention that nothing was decided earlier. All the judgment says 2 things. The judgment speaks about, one is Krishnamar and the other is about Kodak Mahendra. The other day I got about Kodak Mahendra was a manifest error. Kodak Mahendra has nothing to do with the borrower lender relationship. That is commoditarius and commodans. Commoditarius is the borrower. Commodans is the lender. Yes. This is between 2 creditors. sir. And the whole issue is I read only, my lord, to take your lordship to paragraph 31 and 32. As observed herein above, sections 15 to 23 of the MSME Act are providing a special mechanism for adjudication of disputes and to adjudicate and resolve dispute between the supplier and the borrower. The supplier is the MSME, the creditor. At the cost of the petition, it is observed that the MSME Act does not provide any priority over the debt dues of the secured creditor akin to section 26E of the SARFAESI Act. At the most, the decree or order award passed by the Facilitation Council shall be executed as such, and the micro or small enterprise in whose favor the award or decree has been passed by the Facilitation Council shall be entitled to execute the same, like any other desk of creditors. Actually, it is wrong, but we are not concerned about that. It certainly gives primacy. Therefore, they constrain the provisions of section 15 to 23, read with section 24 of the MSME Act and the provisions of the SARFAESI Act, such as there is no repugnancy between the two enactments, SARFAESI Act and the MSME Act. As there is no conflict between the two schemes, the MSME Act and the SARFAESI Act, as far as specific object of priority is concerned, it is of priority between two creditors. And the next paragraph 32. At this stage, the object and purpose of the enactment of the SARFAESI Act is required to be considered. SARFAESI Act has been enacted to regulate the securitization, reconstruction of financial assets and enforcement of security interests, to provide for a central database of security interests created on the property rights and for matters connected therewith or incidental thereto. Therefore, the SARFAESI Act has been enacted providing specific mechanism provision for financial asset and security interest. It is a special legislation for the enforcement of the security interest which is created in favor of the secured creditor and the financial institution. Therefore, in the absence of any specific provision of priority of dues under the MSME Act, if the submission of the submission of the on behalf of the respondent one for the dues under the MSME Act would prevail over the SARFAESI Act, then in that case, not only the object and purpose of the special enactment of SARFAESI Act would be frustrated, even the later enactment by way of insertion of section 26E of the SARFAESI Act would be frustrated. If the submission on behalf of the respondent is accepted, then in that case, section 26E of the SARFAESI Act would become obligatory and would become odious or redundant. Any other contrary view would be defeating the provisions of section 26E of the SARFAESI Act and also the object and purpose of the SARFAESI Act. Section 26E is only about section 26E with effect from 2016. The claims of the MSMEs, claims of the banks which shall prevail over the state government and the MSMEs all, notwithstanding anything contained in either law for the time being enforced. After registration of the security interest, the debt due to the secured creditor shall be paid in priority over the debts of all debts and revenues, taxes, cesses, and other rates payable to the central government or state government or local authority. This statement has nothing to do with the issue before this court. It is completely, and unfortunately, it has been repeatedly referred to. And your lordship statement was a detailed reference about it. This second issue, which was decided, the reference has been made in the judgment which against which the appeal was filed, is Krishna Kumar. The Krishna Kumar, we have Krishna Kumar. May I pass on the copy of the Krishna? Muhammad. paragraph, may I take your lordship to paragraph 15. Instead of troubling your lordship from reading all that, my lord, I read from paragraph 18 onwards. In the earlier two writ petitions, there is not a whisper of the appellant being an. The lordship got it. Yeah, paragraph 18. In the earlier two writ petitions, there is not even a whisper of the appellant enterprise being an MSME. The arguments of the appellant were not aware of the status of the enterprise as MSME is too far-fetched to believe when they had filed the two petitions through legal counsels. Let's secure ignorantly. That is the concept, but that is forgotten. The law is to protect the welfare legislation. The concept is said, let's secure it ignorantly. Law should protect ignorance. In this case, the lame explanation given is that the appellants were unaware of their rights, which we find entirely unacceptable. It is nowhere stated that the appellants are illiterate. Therefore, all we see before us is an attempt to raise repeated challenges in the court to start the repayment. The Nana counts will respond, etc. Then, my lord, yes. Therefore, the concept of acquiescence, waiver, there's a maxim in Latin. Qui lebet potest, renunciaro, proso interdicted. Proso interdicted, that is in the realm of private law, not to come the realm of public law duty. Public law duty, if Parliament has mandated something, you are duty bound to enforce it. There is no question of renunciation, there is no question of waiver, that is the realm of private law. Then in my case, therefore this concept of waiver, acquiescence has no application at all, because this judgment, these issues were never argued. I only appeared, when the judgment came only, I came to know that the court has made this reference to all these things. It was not ever raised at the bar, because the concept of renunciation, we lebet potest renunciare, proso interdictus, is the realm of private law. If it is the concept which is belonging to the.
Yes, come to the next point.
Yes. Now, therefore, here look at on the facts. This is just to the facts of the case. Yes. In my case, may I take your lordship to the sanction letter. It is a page of sanction letter.
So, counsel, this is a review petition.
No, my lord, now,
Yes,
my lord,
yes.
now, my lord, because I
Yes.
say, my lord, where are the
Yes.
actus curiae, nominum grabare.
And also you started arguments without disclosing the fact that your SLP stands dismissed.
No, that, my lord,
Yes.
my lord, if your
That
lordship
is-
want
that
me
is-
to apologize,
no,
I
no.
will do it.
No, that
But there
is-
is there is nothing, my lord,
Yes.
there is no presumption. There is no presumption of concealment, nothing.
Yes.
My lord, there is a fundamental principle. There is a fundamental. The more presumable, nobody perceives bad, my lord. There is a presumption that nobody is bad.
Yes.
The more presumum, sorry, that I am forgetting. The more presumumundar malis. The more presumumundar malis. Nobody is presumed to be bad. Everything has to come. The other side, somebody has to put on an affidavit. Yes, something was concealed.
It's
Nothing
not a
was
question of, Mr. Counsel, it's not a question of concealment.
Yes.
When your SLP
No,
stands
my lord,
dismissed on 9/7.
my lord, I
you should
apologize.
have-
I
yes.
apologize.
Yes.
My lord, let us travel to that other
Yes.
I take your
Yes.
lordship to. I take your lordship to the sanction letter. The sanction letter, your lordship will find at page 231. 231 of the writ appeal. Page 231. Page 231, my lord. Yes. Business segment. Your lordship will get Somewhere in the middle part. Page 231.
Yes.
Business segment, MSME. MSME, retail, agriculture. Then, if MSME, whether micro, small, or medium, small enterprise. If MSME value for investment in plant and machinery, 3.47 crore MSME investment. So I'm an MSME. The loan was granted as MSME, and the statute does not cast any burden on me to inform them, make application, nothing. This terminology, because not only interpret a statute. No judgment can be read as a statute, no judgment can be read in substitute of a statute. Notification. I take your lordship notification. Yeah. Notification. I got it.
Yeah, first aid box.
Yes, sir.
Yes. This is because I am on a pure question of law. What the parliament has ordained is a welfare legislation, it is a preventive legislation, it is a remedial legislation. If something is missing, the concept of fortis in verbis, nulla ambiguitas, expositio contra verba fonda, expressa est. If something is missing, this is duty of the court to supply it. But there is no need for anything supply. This word deployed is crystal clear. The paragraph 2 may not take the paragraph identification by enterprise. Any micro, small, page 70
Yes.
any micro, small or medium enterprise may voluntarily initiate the proceedings under this framework if any enterprise reasonably apprehends its failure of its business or its inability or likely inability to pay debts, and before the accumulated loss of the enterprise equals to half or more of its entire net worth.
Counsel, this is the very same provision which you pointed out on the previous.
My contentions are never recorded. No, my contentions are never recorded.
Yes.
My contentions here. My contentions are never recorded.
This is the very same provision which you pointed out on the previous day.
No, fine, but the question is.
Now this is the second day.
The question is, if the who is at fault?
Yes.
Ex debito justitio, yes, debito justitio. When the court is at what is a human institution? The Pope, Justice Hariman has quoted Roma, Locuta, yes, Gaza, Vinita, yes. I am not reading from Justice Hariman judgment. So Rome, the Pope, which claimed that he is infallible because he is prevented by the Holy Spirit from committing any error, has kept on apologizing for the sins of the past. So, therefore, the duty is cast and relying on Anjali. Anjali is wholly on that. The concept of intention, dependence. This is the Vivian Ghosh statement in Surendra Singh. Repentance. A court has made a mistake. What is duty bound to? It's a human institution. Nobody is. What is not infallible? Supreme Court is Justice Marshall says Supreme Court is supreme, not because it is infallible. It is infallible because it is supreme. I attribute the same to a magistrate munsif. A munsif says 1 plus 1 is 0. I accept it on facts. That is not would be answered. The concept is the court has a power to err on facts only. Res judicata facit. On facts. A thing which is judicially decided on facts. Res judicata facit. Ex albo nigrum. If a court says on facts, black is white, white is black, it is black. Ex res judicata facit. Ex nigro albo nigrum. Album is white, nigrum is black. Ex nigro album. Nigrum is black, album is white. Ex recto garvam, rectum is straight, garvam is crooked. Ex curvo rectum. So therefore, a judicial decision can make what was white black, what was black white, what was straight crook, what was crook straight. That power is within on facts. The court is a servant of law. We are all servants of justice, servants of law. See, for me, I always treat judges as equal. Lawyers and judges are equal because both of us are servants of justice. See, my job is, there's one fundamental principle I always keep in my mind. So they said that's not my words. I always quote it. The great Lord Chancellor's way. I know only one person in the whole of the world, and that person is my client. Justice Matthew has quoted in Indira Nehru Gandhi's case. Justice Matthew has said that man whom you claim the only person who know on the earth is maybe somebody who stab you in the back, and you fight for him. The society may, consider to be a bad right, and he has to argue his case fearlessly, fearless of the judge, fearless of the society, and fearless of the litigant who may stab you in the back. That is, it's not my words. Justice Matthew has quoted, not winning. So therefore, my lord, here, court has made a mistake, and I am very confident. I have two judgments right away. This is another set of petitions. In Manisha Mehta's case, she was the president of the MSME Association. Everywhere she went without properly considering dismiss. But she was a fighter. I'm just giving a list of cases. List of cases. In the order dated 15/7/2015, at the hands of Suryakanth came after the Justice Balabala dismissing her case, the bench of Justice Khanna dismissing her SLP. Review petition was filed with Balabala has been dismissed. Then review petition was allowed by the bench of Justice Suryakanth. And after that also, then NCLT passed some orders denying the benefit of the foreign case. And thereafter suit was filed. Suit to interim injunction was denied by Justice Puniwala. Appeal was filed before Chief Justice Arade and Justice Badi Danke. SLP was filed like the other day. SLP was filed. Justice Divanga Datta and Suryakanth dismissed it. We did not give hope because we believe in law. We believe in the institution. Judicially, we believe in judges. We filed a review petition. Review petition was allowed. Review petition was allowed. 16 pages judgment of Justice Badi Danke. Allowed. Because there is no estoppel against law. Fundamental principle, universal. Whatever the legal system we follow, that is founded on Roman law, based on the philosophies of great lawyers like Ulpian, Parmenian, Montesinos, Caius, and who else? Parmenian and
so counsel, come to the
yes.
point.
No, I am on the point. Therefore, I am saying here that the point I canvassed is, I am under no obligation to make an application. You are under a duty, the bank is under a duty to constitute a committee. You did not constitute a committee, you violated the law, and therefore the statute does not prescribe any punishment for violation. Many statutes prescribe. Only thing I can seek the action against under the 36AA of the Reserve Bank of India Act for removing the chairman and managing director, etc. But there is no other provision directly under the MSME Act. Therefore, the only consequence is declare, quash and set aside whatever has been done illegally. Whatever has been done is a nullity, therefore written in the nature of certiorari. My prayer in the petition all throughout is written in the nature of certiorari, calling for the entire records and proceedings leading to X, Y, Z. Quash and set aside the same. And in the written in the nature of certiorarified mandamus directing them to constitute a committee, extend the benefit, and tomorrow they find that the resolution of stress is not possible, recover it. There is nothing prevents them from recovering. Nobody is taking away their security there. All my documents are with them. Everything is with them. And I have not raised any contention other than no contention based on the fabrication vote, nothing. What I have raised is a simple legal contention. It is not my fault. It is not the fault of an MSME. The whole system failed. Miscarriage of justice. I may write a book. I am writing actually. Miscarriage of justice. This sector, because the court's duty is to not to legislate. Court duty is to enforce. And when somebody comes to the court complaining that a statutory provision has not been given effect to, then he is entitled in law. What a litigant is entitled in law cannot be denied. And that came to be denied in the case by the hands of single bench. The single bench has not discussed what is my case. I argued. If anybody want me to affidavit, file an affidavit, these are all recorded. So if somebody wants to, because single judge may say, make a mention about I record it. I believe that, see, it is the fundamental principle that no good man should obey law too well. There's a reference about it. Video recording, and I started a campaign for video recording of court proceedings. So therefore, everything is recorded, contented. What I argued was not there in the judgment. What will I do? I can file a review. In all the cases except this, because there is immediate dispossession, I file an SLP straight. It can be admitted by the bench of Justice Narasimha. The similar matter, the matter was dismissed. I appeared online. What is that? What can I do? I don't have any control. Therefore, Article 137 of the 137 is already been called dead letter. We have the statistics. 99.5% of all 137 petitions are dismissed in chambers, no hearing, nothing. And our legendary Krishna here only said, yes.
Counsel, those arguments have.
No. Therefore, my lord, my lord, here, my grievance when I came before your lordship is, my grievance is that justice, the greatest respect, the bench of justice, Govinath, did not at all record my case. Instead of recording my case, he record somebody else's case. How am I concerned with Krishna Kumar? I'm not Krishna. I'm not a literate man. I'm a literate man. I made an application. When the 13-2 notice came, it may take your lordship to my reply. 13-2 notice. Reply to that. I only said nothing else. I only said I am an MSME. You have violated the law. Yes, may I take your lordship to page 83. Page 83. This is my reply. Yes. MD MSME is registered as a small enterprise under the MSME, etc., etc. I not trouble your lordship. Then my lord, at paragraph 8, statutory guidelines provided by the government of India, etc., 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 etc. Yes. Were not adhered to prior to the issuance of this notice under section dated 16 August 2023. Guidelines should have been mandatorily followed. So where is, and next page also I am repeating. Yes, the statutory direction of the Reserve Bank, etc. Action be taken under committee for corrective action plan were not adhered to before the issuance of the notice. The bank should have formulated a committee for a corrective action plan, which emphasizes a comprehensive mechanism for resolution of stress or MSME, formulating committees, etc. Then there are para 5, para media enterprise, etc. Then again, my client seems to have spoken even in Latin. Para 6, notice dated 16 August 2023, claim to be issued by under 13.2 of the SARFAESI Act is in violation of the statutory directions, and therefore void ab initio. Hence, knowledge in the eye of law, and for the proceedings based on illegal notice, it will also be illegitimate, arbitrary, malafide. I'm not an illiterate man, which Justice, the Chief Justice has referred to in the Krishna Kumar. Then I'm an illiterate man. Reference to an illiterate man has been made. I'm not illiterate. Then, my lord, now coming in that case. Here I am not an illiterate. This is Krishna. Then may I take your lordship to paragraph 19. Chief Justice Nadim Jandar is known for beautiful judgments. Very balanced, very respected judge. But human error, that's all. Appellant's argument. Bombay High Court is one of the finest of judges. Para 19. The appellant's argument that the High Court must intervene no matter how they conducted themselves. Proceed on a complete misunderstanding of the nature of repetition. There are two separate issues. One, whether bank they lack the authority to proceed. Yes. Second, whether the appellant's conduct disqualifies or disadvantages from them invoking equity jurisdiction. So, my lord, here, I'm not for any charity or even equity. What I'm asking for, and what the statute provides. In cases where a borrower qualifies as an MSME, does not initially raise his status to challenge the bank's recovery proceeding under the SARFAESI Act, but instead participates fully in the process without objection, cannot later use their MSME status to argue that proceedings were without jurisdiction. So these facts are completely different. Krishna Kumar, yes, I am not concerned. I am not a party to that. If I am a party to that, right or wrong, Jurisdicata. If I am not a party, the concept of res inter alios acta, altori, nosori, non the first principle. Yeah, in a case, a decision in a case between A and B will bind A and B, not C and D who are not parties. That's the fundamental principle. Therefore, the Krishna Kumar has nothing to do with, and none of my contentions does not find any reflection at all in the judgment which is under review. Which is under appeal. Then, my lord, now in the judgment under appeal also, your lordship finds, this is what I argue. Your lordship rightly said, I only said one thing, my arguments can be canvassed in few words. Namely, I am an MSME, entitled to protection. There was no obligation to apply. You are aware that I am MSME, and that is Vela Trivedi's judgment says, Vela Trivedi only out of concern for the bank's interest only said, if, I only argue that matter. The ladyship kept on asking, how an MSME, how a banker will know whether you are an MSME. That is all that said. Therefore, the judgment only said, yes, the borrower, it is up to, it is. Thank you. Now, I take your lordships to paragraph 18. Not that I am relying on judgment. I have written an article that burn all law reports so that there is justice. Because we have to follow the system, follow the civil law countries. Follow the statute. Even in America also, they don't write thousands-page judgments. They follow the statute. So far as my little understanding, I am trying to learn the system in the rest of the world. I am a student. Yes. My lord, paragraph 18. In that view of the matter, we are of the opinion that findings recorded by the High Court include order that the banks are not obliged to adopt the restructuring process on its own, or that the framework contained in the notification, etc., remains, etc., cannot be mandatory in nature, are highly erroneous and cannot be countenanced. The instructions, directions issued by the central government under Section 9 of the MSME Act and by the RBI under Section 21 and Section 35 of this have statutory force and are binding all banking companies. This is all what I ask. If it is binding, you have to contribute to that. And whatever has been done, a writ of certiorari, that is my main prayer, written the writ of certiorari. And I may ask for other mandamus and declaration. Proceed against them. Remove the managing director. All the many things I have to ask for. But the primary, the core is, yes, whatever has been done has to be set aside. And the judgment, Justice Bela Trivedi only has said, the ladyship has said, take your lordship to paragraph 17. So therefore, a judgment, one word here and there in a judgment cannot be picked up and used against, cannot give to give a meaning contrary to what the judgment says. The concept of what Utteras, which is mediate, ex reservibus actus, these concepts, the judgment has to be read as in its entirety. Para 70. It is also pertinent to know that sufficient safeguards have been provided under the said chapter for safeguarding interests of the defaulters, borrowers, for giving them opportunities to discharge their debt. However, if at the stage of classification of the loan account of the borrower as NPA, the borrower does not bring to the notice of the concerned bank or creditor that it is an MSME, under the MSME Act, and if such an enterprise allows the entire process of enforcement of the security in the SARFAESI Act to be over, it having challenged the action of the concerned bank or creditor in the court or tribunal and having failed, such an enterprise cannot be permitted to misuse the process of law for thwarting the actions under the SARFAESI Act by raising the plea of being an MSME at a belated stage. So I certainly don't consider these observations are correct, but let us assume these observations are binding declaration of law, assuming. But in my case, it has no application. I am an MSME, the loan itself is an MSME, I did not sleep over my rights. Vigilanti no dormianti Serbian Gajam. That's a concept of, it's a concept, equitable concept, not a legal concept. There's a distinction between law, equity and law. Equita, sequitur, rajam. What cannot be if something is my property? Unless I sleep over beyond the statutory period of 12 years, I still can raise it. If something is mine, I declare that it is not mine. It doesn't cease to be somebody else. A right cannot be created either by assertion or negated by denial. But except in a judicial proceedings. That is also a debatable issue. So therefore, what did I wrong? What is the mistake I did? What was lacking in me to gain the benefit of the statutory benefit? What more I am required to do? Nothing. Nothing I am required to do. And I am entitled to compensation and damages. I filed a suit in Bombay, paid court fee. Because in Kerala to file a court fee, you have to pay 10 times more. Court fee is impossible to file. So therefore, if that petition is maintainable or not, that is an issue which is difficult to decide there in Bombay. So therefore, what more I do? I am denied justice. That is what my grievance. And I was taking your lordship to Justice Nariman's statement. Justice Nariman's statement. Here, that was a case where something was decided and there is a res has been decided, there is a res judicata. For a concept of doctrinal res judicata to apply, most fundamentally is there must be an adjudication on the merits, at least constructively. In my case, there has never been any decision, any adjudication on merits. I only came 3 times to this court. First time I came, I was asked to go to the DRT. Second, I came, not only when there issue for a vehicle being taken possession, except I came for something to the High Court rejected it, asked me to go to DRT. And I went to the Bombay High Court. There the Bombay High Court knew that you have to institute a petition Kerala High Court. And nobody has decided anything. Nothing. There is no estoppel, there is no cause of action estoppel, there is no adjudicator, nothing. Merger, nothing. Issue estoppel, nothing. There is no, these are the concepts. There is no waiver, there is no accusation, there is no estoppel, there is no issue estoppel, there is no cause of action estoppel, there is no adjudicator, there is no merger, nothing. I came literally for the first time on being directed by the Bombay High Court, and the matter was argued before Justice Gopinath. And there, my conventions were not recorded. Nobody on earth said Midambara didn't open his mouth. Never I did. It was never recorded. And my lord, now, therefore, I am a victim of injustice. And my lord, I take your lordship, therefore, this is Nariman's statement, I don't have to rely on because that was a case, a suit was decreed on merits, and it has reached finality. And then asking for reopening on the ground that what was decreed, what has received the finality is something which is contrary to public policy. So I only read 2-3 sentences from the statement as my lord Justice Nariman, as my lord at page 260. 34.2.2. I read one sentence before. Can I take your lordship, my lord? An issue of law which arises between the same parties in a subsequent suit or proceedings is not adjudicated if by erroneous decision given on a statutory prohibition in the former suit or proceeding, the statutory prohibition is not to be given effect to. Tomorrow I file a petition before the single bench. Yes. Even then I am protected. Yes. So this is the effect of this is despite the fact that the matter and issue between the parties may be the same as that directly and substantially in issue in the previous suit or proceedings. So, my lord, how sweeping is his statement? This is despite the fact that the matter and issue between the parties may be the same as that directly and substantially in issue in the previous suit or proceeding. Section 11 CPC. Yes. This is for the reason that in such cases, the rights of the parties are not the only matter for consideration, as is the case of an erroneous interpretation of a statute inter partes, as the public policy contained in the statutory provision cannot be set at naught. This is for the same reason as that contained in matters which pertain to issues of law that raise jurisdictional questions. Now we have now seen now that so and so is the. I'm not reading the. Oh, sorry. It is the public policy of the statutory provision contained in Section 28 of the Bombay Rent Act that has to be given effect to. Likewise, the public policy contained in the other statutory provision, which need not necessarily go to the jurisdiction of the court, must equally be given effect to. As otherwise, special principles of law are fastened upon parties when special consideration made to the public policy mandate, and this cannot be done. So, this judgment I need to rely on if I file a fresh petition before the single bench. So, therefore, this the fundamental principle, one word, ultimately, Sudiketa, Prasit, Exalto, Negro, Alpha, Ex Recto, Garvam, Ex Garvo, Rectum. There is no estoppel against law. This is a universal principle. Now, coming, this principle has been reaffirmed in Anduli. I will not trouble your lordship with so many judgments. I will not trouble your lordship because Andile is so exhaustive. It is with so much of clarity and great elaboration, has dealt with everything. The doctrine of nullity. The doctrine of my client is not drafted by my client. My client himself drafted, I believe. Void ab initio. If something is done contrary to law, then it is under void ab initio. Something which is vitiated, the authorized office is a tribunal. So it may create a substitution of the Supreme Court. And the committee to be constituted under the MSME Act is also a tribunal. So when the tribunal has not been constituted, nor reference to the committee has been made, and when the authorized officer has acted contrary to the notification, there is a violation of the express statutory provision. If something is done in violation of the express statutory prohibition here, or if something is done in violation of the principles of natural justice, and if something is done without jurisdiction, all this comes here because the authorized officer has no jurisdiction to act except on the permission of the committee. I will tell your lordship one second, one page only I read. Paragraph page 73, paragraph 3, only one page. This is what Justice Nitin Jamdar has taken notice of that. It is without jurisdiction. Admitted. Authorized officer's action is without jurisdiction. Once the first two options at A and B, the lordship going to place at the bottom of the notification. Of the notification. By the bottom, by the 73 bottom. Recovery. Once the first two options at A and B above are seen not feasible, due recovery process may be resolved. Committee may decide the best recovery process to be followed. The committee certainly has the right to permit among the various legal and recovery options available. And the committee is a judicial forum. It's a judicial tribunal. Trouble your lordship, one sentence I read from paragraph 15. The characteristic, as has been said in Ujambai, the characteristic of judicial tribunal that it can bind the parties by its decision, that is notification says, and at page 78. Review. In case the committee decides that recovery action is to be initiated against an enterprise, such enterprise may request for a review of the decision by the committee within a period of 30 working days from the date of receipt of the decision of the committee. The request for review shall be on the following ground: an error, a mistake or error apparent on the face of the card. The order 47 rule on CPC, discovery of new and relevant facts, etc. Therefore, my contention has been the entire action is without jurisdiction. And if something is done without jurisdiction, it is vitiated by error apparent on the face of the card. And my further contention has been, once something is done without jurisdiction, the jurisdiction of the civil court is not outside. I'll give my thought. The principles have been summarized in your lordship will find at page. There's no pagination. Pagination is there? Page 17. Page 17. Page 17. Your lordship will find at the top. Page 17. Problem, my lord, the results of the inquiry to diverse use expressed in this court may be stated as follows from the bottom, somewhere here. Lordship got it? Somewhere here. Where a statute gives finality to the orders of a special tribunal, the civil court jurisdiction must be held to be excluded. If there is an adequate remedy to do what the civil court would normally do in a suit. Such a provision, however, does not exclude those cases where the provisions of a particular act have not been complied with, or the statutory tribunal has not acted in conformity with the fundamental principles of judicial procedure. Here, the MSME Act creates certain rights in my favor, certain obligations also against me, and casts responsibilities and burdens on the banks and financial institutions. And the notification does not create any tribunal for the enforcement of the same. Therefore, the jurisdiction of the civil court is not outside. Where there is an express bar of the jurisdiction of the court, an examination of the scheme of the particular act to find the adequacy or sufficiency of the remedies, etc. Then, yes. Challenge of the provisions of the particular act as otherwise cannot be brought before the tribunal constituted. Even the High Court cannot go into that question on a revision or reference from the decision of the tribunal. So civil court can declare act of parliament unconstitutional. When a provision is already declared unconstitutional or the constitutionality of any provision is to be challenged, a suit is offered. A retrocertiorari may include a direction for etc. Then where a particular act contains no machinery for refund the color, etc., suit lies. The questions of the correctness and assessment, apart from its constitutionality, are the decisions of the authorities, and the civil court does not lie if the orders of the authorities are declared to be final, or there is an express prohibition of the particular act. In either cases, the scheme of the particular act must be examined because it is relevant inquiry. An exclusion of the jurisdiction of the civil court is not to be readily to be inferred unless the conditions above set down apply. Here the principle is the MSME Act creates certain rights and obligations, but it does not provide for a forum to adjudicate the interstate dispute, and therefore the civil court jurisdiction is not ousted. So I can go to the civil court. Then, my lord, now the 19th Constitution bench has said that the number of judgment says that I can invoke, assuming that there is a tribunal also, for adjudication of disputes of interstate dispute between the borrower, the banker, and then under the MSME Act, assume there was a tribunal in existence. Then also the jurisdiction of the discord under Article 226.
What is this bunch of decisions? What is the point?
The point I canvass is where the Dilabai many other decision has been discussed and say when a statute creates certain rights and obligations in my favor in the asset case and cast burden and liabilities on the other, and such a statute does not provide for any special forum, the jurisdiction of the civil court is not outstanding.
These type of arguments can be advanced in a review petition. Citing various decisions, none of these were cited during your hearing.
No, nothing new.
This is a review petition.
No, I always said, my contention all throughout is, because citation is something to, because this is undeniable. Assume that there is no citation. My contention is, whereas the tribunal contemplated under the MSME Act is a judicial tribunal, and if a person, where no such tribunal is constituted, or a person agreed by the decision of a tribunal, no forum for enforcement of the provisions of the Act is provided for. In such a scenario, the civil court jurisdiction is not outstanding. And then the further contention is assuming for argument's sake that there in existence a tribunal or a forum to enforce the dispute under the MSME Act, then also the jurisdiction of the under 226 can be invoked. So this is, but I always sort of like it because it at greater extent it explains it.
Yes, what is your next point?
Yes. Shall I read paragraph 327 of the Dilabai? Paragraph 327. Applying the law laid down in the decisions as aforesaid. It is, if I am reading is in the Govinath did not make any reference that you have an alternative forum, etc. But in your lordship's judgment, there is reference to that jurisdiction under Article 226 is barred. You have to invoke the jurisdiction of the DRT. My submission is, for a dispute in the realm of enforcement of the MSME Act, the DRT has no jurisdiction. That DRT is contemplated only to adjudicate dispute on the enforcement of the SARFAESI Act and not under the MSME Act. That is the core. And therefore the jurisdiction of this court under Article 226 is not outstepped, and I cannot be asked to go to DRT. Yes. 327. Applying the law laid down in the decisions aforesaid, it is not possible to conclude that any and every claim for refund of illegal or unauthorized levy of tax can be made only in accordance with the provisions of the Act. And an action by way of suit or repetition under Article 226 will not be maintainable under any circumstances. An action by way of suit or a petition under Article 226 of the Constitution is maintainable to assign the levy or order which is illegal, void, or unauthorized and without jurisdiction, and or claim of refund in cases covered by Proposition 1. 3, 4, and 5 in the Labai case as explained in the above, as one falls outside the Act and aggravate. Such action will be governed by the general law, and the procedure and the period of limitation provided by the specific statute will have no application. Rule 11, before and after the amendment of Section 11B cannot affect Section 72 of the Contract Act or the provisions of the Limitation Act in such a situation. My answer to the claims for refund broadly falling under the three categories or the categories enumerated in para 290 of this statement are as follows. Where the levy is unconstitutional outside the provisions of the Act or not contemplated by the Act. In such cases, the jurisdiction of the civil court is not ousted. The aggrieved party can invoke Section 72 of the Contract Act, file a suit or a petition under Article 226 of the Constitution and pray for appropriate relief, inclusive of refund within the period of limitation provided by the appropriate law. Category 2, where levy is based on misconstruction of erroneous interpretation of other provisions of the Act, rules of notification, by failure to follow the vital or fundamental provisions of the Act, by acting in violation of the fundamental principles of judicial procedure, statutory tribunal or authority tribunal, irrespective of its gravity or nature of the infirmity, will not be covered. It is confined to exceptional cases where the provisions of a particular Act have not been complied with, or the statutory tribunal has not acted in conformity with the fundamental principles of judicial procedure as stated in Mask and Company and in the Labai case. The scope of the above dicta should be understood in the background of or in accordance with the observations of the earlier constitution bench in so and so versus so and so. Then, category 3, mistake of law. A levy or imposition was unconstitutional, illegal, or non-exigible in law, and that is without jurisdiction, and so found in a proceeding initiated not in a particular assembly, but in a proceeding initiated in some other assembly, either by the High Court or the Supreme Court. And as soon as the assessee comes to know of the judgment, within a period of limitation, he initiated action for the refund of tax paid by him due to mistake of law. So in these categories, all allow the suit or ritual lie. So there is the tribunal. DRT has no jurisdiction. That has to authorized be my contention, and there is no reference at all in the judgment of the Vela signature or in the of your township judgment. There is no reference at all.
Yes, now we will hear the other side. Yes.
I don't think it's hearing that report. I will only mention take just 5 minutes of that. Now, the order on the SLP was not to this court, so the only matter right. Because my friend is interesting a lot. In fact, I would say even at the issues the other day, should have mentioned that I am opposed. It's not a bar. I'm not on the question of merger or adjudicator. My friend is acting eloquent on that question. I'm not on that. I'm only on the question of propriety. So this is the first thing you should have, because this is what happened from the last hearing of before this court and this hearing. So it's germane that this is brought to this court. That's nothing more than that. Because I have my own views on merger, etc. It's not relevant to this. Now, may I take my lords to the new petition itself. At page 8, let us see what the grounds are. I would reiterate, this is not a hearing, re-hearing of the record. My lords have heard the reading and judgment has also been delivered, which has been upheld by the or the SLP has not been admitted. So to that extent, there is finality. Now, regarding the grounds raised by on page 8 of the review petition. Ground 8.
Yes.
On page 797. Page 8.
Yes.
Ground A is the impugned judgment suffer from factual and legal errors apparent in the judgment and refuse the same is warranted. I would say it's grossly inadequate ground because if my lord is to consider a specific aspect of a judgment which is erroneous, that has to be pointed out. It is not an overwhelming, it's not an omnibus ground we can take in this opinion. Then B, as per interpretive rule of plain and literal interpretation, Exhibit B2 notification does not permit this honorable court interpretation only if the MSME borrower brings into notice the creditor prior to the classification of its account as an NPA. That is an MSME entitled to benefits of Exhibit B2 notification. The MSME borrower can rely on B2 or that Exhibit B2 does not have the applicability if the MSME borrower does not bring into notice the creditor or of its MSME status. This is a matter which is argued prior, which has been held against the judgment on various grounds. Two of them are the company is not entitled to the benefit of an MSME because it's the limit of borrowing exceeds 25 crores. Second one is that the bank had brought into notice that you are SMA status like thereafter nothing was done. Only after it was declared as NPA, the notice was sent at the expiry of 60 days, so just prior to he took up his condition. These two aspects have been considered by Lord. My Lord may be wrong, but that is for the apex court to consider. This is not an appeal. Then C. Exhibit B2 mandates the secure creditor dehouse any action on the part of MSME borrower to identify and assuage incipient stress faced by MSME borrowers and assuage it on various measures, including restructuring, additional financing, etc. This again is a matter which is argued and considered by my lords in the judgment. D. This honorable court failed to consider and apply the law laid down by Honorable Supreme Court in Cody versus Board of Directors of Canara Bank and others. Now, this is again a matter which is argued and considered. Then there is E. There is no estoppel against the statute. The petitioners cannot be barred from relying on Exhibit B2 statute notification, mandating a procedure to be followed before initiating recovery measures against the MSME borrower. Again, a matter which is argued, held against him. F. Then it talks about honorable court is vested with jurisdiction in entertain all cases involving violation of statutory provision in spite of the availability of statutory remedy against but no error pointed out. Again, finding of this honorable court reduces Exhibit B2 to redundancy, defeating the objective of MSME Act 2006. In addition to directing banks and other creditors to follow procedure laid down as regards stressed MSME borrowers. Exhibit B2 also permits MSME borrowers to apply to the bank for benefit of notification. So these are all only statements. Nowhere is any specific error. Now on this ground, I would say there is a judgment which recent judgment which I take my notes to page 8. So this is discussing a appeal from a civil matter, but then principles are the same. Page 8, starting with paragraph 14. Paragraph 14 onwards. In Colonel Avtar Singh Shekhar versus Union of India and others, this court observed that the review of an earlier order cannot be done unless the court is satisfied that the material error which is manifest on the face of the order would result in miscarriage of justice or undermine its soundness. The observations made are as follows, as under. A review is not a routine procedure. Here we resolve to hear Sri Kapil at length to remove any feeling that the party has been heard without being heard. But we cannot review our earlier order unless satisfied that material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. In Saudagya Chandra Kande versus others, a review of a judgment is a serious step, and reluctant resort to it is proper only where a glaring omission or a blatant mistake or grave error has struck earlier by judicial fallibility. The present stage is not a virgin ground, but review of an earlier order which has the normal feature of finality. Next para. In Passion, Devi and others, uh, stating that error that is not self-evident and the one that has to be detected by process of reasoning cannot be described as an error apparent on the face of the record for the court to exercise power to review this court held as under. It is well settled that review proceedings have to be strictly confined to the ambit and scope of Order 47 Rule 1 CPC. It's so and so is so and so. What, however, the court domain. What, however, we are now concerned is with whether the statement in the order of September 1959 that the case did not involve in substantial question of law and error apparent in the court. The fact that the earlier petition the court held on the identical state of facts that a substantial question of law arose would not per se be conclusive, for the earlier order itself might be erroneous. Similarly, even if the statement was wrong, it would not follow that it was an error apparent on the face of the record. For there is distinction which is real, though it might not always be capable of exposition, between a mere erroneous decision and a decision which could be characterized as vitiated by error apparent. The review is no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. Now the highlighted portion, para 9,
Yes.
third line onwards. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court exercise power of review. Goes on with the same lines. So my submission is,
Yes.
if my friend has to argue so much in an attempt to convince this court that this court judgment has some error apparent on the face, by that feature itself, I would submit review. And then my friend has tried his luck with the apex court to reject it for whatever reason. I would say in view of that, this review would not lie.
Yes. Thing in
I very briefly, I stand by this. If it is a factual error, not a real line. It is a pure error apparent on the face of record is always a legal error. That is all. I am in complete agreement with this statement. And then the question is, I am only reading a few lines from the Anduli. Therefore, when there is a legal error, no procedure, no form, nothing, the court is duty bound to do ex debito justicia. I'm just making a few references, few paragraphs. It's a celebrated judgment, a few paragraphs. I won't take time. Only a few paragraphs of the celebrated judgment in Andhra's case. Only a few paragraphs. At page 652, I'm reading only a few sentences only. I read, not this paragraph. 652.
Page?
Page 652. 652. Sorry. Middle part, in rectifying the error, middle part of the first paragraph. In rectifying the error, no procedural inhibition should be debar this court because no person should suffer by reason of any mistake of the court. The court, as is manifest in its direction, etc. Here, no rule of res judicata would apply to prevent this court from entertaining the grievance and giving the appropriate directions. And sit down last sentence, where the dear Desai, etc., speaking for the Gujarat, he observed that no act of the court or irregularity can come in the way of justice being done, and one of the highest and the first duty of all courts is to take care that the act of the court does no injury to the suitors. Sit down, my lord, paragraph 42. Yes. Very ignorant this is. I am not reading that. Okay. Then coming to paragraph 44, I skip then 47. At the end, last sentence. It is a settled rule that if a decision has given per incuriam, the court can ignore it. It is also true that the decision of this court in a case so and so etc. was not regarding etc. Then coming down paragraph 48. According to C. Jatulani, the doctrine of per incuriam has no application to the same proceedings. We are unable to accept this contention. We are of the opinion that this court is not powerless to correct this error, which has the effect of depriving a citizen of his fundamental rights and also the right to life and liberty. He can do so in the exercise of his inherent jurisdiction in any proceedings pending before it without insisting on the formalities of a review application. Power of review can be exercised in a petition filed under Article 136 or Article 32 or under any other provision of the Constitution if the court is satisfied that his directions have resulted in the deprivation of the fundamental rights of a citizen or any legal right of the petitioner. Then my lord, at page 656, only one word I read from the middle in the italics. It was emphasized that at page 656. It was emphasized that an order of this court which could make it in order to complete justice between the parties must not only be consistent with the fundamental rights guaranteed under the Constitution, but it cannot even be inconsistent with the substantive provisions of the relevant statutory laws. And the basis 656, last sentence is last part, that made last sentence. If that was so, as in Premchand's case, that was a mistake of a great magnitude, that it deprives a man of being treated differently of his fundamental right of defending himself in a criminal trial according to law. If that was so, then when the attention of the court is drawn, the court has always the power and obligation to correct its ex debitio justitium and treat the second application of its inherent power by its inherent power as a power of review to correct the original mistake. Then paragraph 54, only one sentence I am reading. Considering the questions whether the subsequent proceedings we can go into the validity or otherwise of a previous decision, the question of law inter partes. Then the court goes on to hold that my lord it can. Then I take your lordship to page 57. Page 57, one sentence. See the observations of Attorney General, etc. Where is at page 661. 661. It was last paragraph. It was reiterated that the creation of a right of appeal is an act which requires statutory legislative authority. Neither an inferior court nor a superior court nor both combined can create such a right, it being the limitations and restrictions of jurisdiction. See also the observations in so and so where it was reiterated that by the Privy Council that if an order is regular, it can be set aside by the appellate court. If the order is irregular, it can be set aside by the court that made it on an application being made to that court, either under the rules of the court dealing especially with setting aside of the irregularity or ex debite justitiae if the circumstances so warrant. Then, my lord, in the same paragraph, the fact that the objections was not raised before this court giving directions, etc., cannot amount to any waiver. There is no waiver against fundamental rights. And paragraph 60, referring to Nawab Khan. Then, my lord, paragraph 62, one second from the third line. Unless a plea in question is taken, we cannot operate as a judicator. Then coming to paragraph 72, only one sentence I read. 76, page 669. Page 669. Paragraph 76. Skipping the first line, second line. If an order is regular, it can only be set aside by the appellate court. If it is irregular, it can be set aside by the court that made an application being made to that court, either under the rules of the court, dealing especially with the setting aside of the orders of irregularity or ex debito's justicial if circumstances were warranted. If my case was that this court held 1 plus 1 is 0, then no review will lie. Only appeal will lie. Nothing else will lie. So this then paragraph 76 last sentence. We are correcting an irregularity committed by the court, not on construction or misconstruction of a statute, but on perception of certain provisions or certain authorities which would amount to the derogation of the constitutional rights of citizens. Then I conclude, my lord, I take your lordship to only one or more sentences on Lord Cairns in so and so verses at page 8672, para 82. Or I will skip that even. Paragraph 83 only I read, my lord. Paragraph 83, middle part. The basic fundamentals of administration of justice are simple. The lordship, para 83. I'm reading the last two sentences. Para 83 at page 672. The basic fundamentals of administration of justice are simple. No man should suffer, or I would say shall suffer, because of mistake of the court. No man should suffer a wrong by technical procedures or irregularities. The rules of procedures are handmaids of justice and not the mistress of justice. Ex debitio justitiae, he must do justice to you. If a man has been wronged, so long as it lies within the human machinery of administration of justice, that wrong must be remedied. This is the peculiar fact of this case emphasized. Because paragraph 86 it says, let that wrong be therefore be remedied. Let right be done. And in doing so, let no more further injury be caused to the public purpose. So therefore, my lord, my contentions are purely on a legal contention. I am entitled to benefit of the notification that was denied to me. Whatever proceedings were initiated were liable to be declared as null and void. These contentions were never considered at any point in time.
We'll consider your argument. During the course of arguments, today we heard of further arguments. On 4/7/2020, when this review petition came for consideration, we heard arguments of the Land Council for the petition being brought. As requested by the Land Council for the petition, that was ordered to be considered. Today, we heard arguments of the Land Council for the petition. During the course of arguments, the Land Council for the respondent pointed out that SLP Civil number 17263 of 2020, filed by the petitioner in RP number 797 of 2025 against the judgment of this court dated 24/6/2020. In appeal number 484 of 2020, entered in dismissal by
With your lordship's most gracious permission,
by the order dated by the order dated 9/7/2020. Heard detailed arguments of the Land Council for the petition, and also the learned. You are the standing counsel. Learned standing counsel for also ban for the respondent. For judgment on the order. for order on 28/7/2025 at 4:50. Case don't use that word here, apology and all. If you are not here, you can say sorry. So we asked because on the standing council we asked what is the section. See, this is not a selection because normally there is a selection for or appointment process for non-healthy trustees that are being conducted by either by the commission or by the area committee. Those are matters normally this court interfere. This is an internal thing that is being conducted by because this is a trustee board consisting of hereditary trustees. That is governed by a scheme. It's a civil dispute. What is this statutory role? Suppose that order, suppose if you are feeling agreed by any decision or the process of election, you are having a statutory appeal. That is under the scheme. Whether that can be considered when the process of election is going on. That is only that.
They will take any appropriate action.
No, this is a process of election. If it is not conducted properly, then your remedy is to avail the statutory remedy. The 226 is very clear. And that is the reason we ask a specific question. The scheme അനുസരിച്ചിട്ടുള്ളതാണ്. And scheme is being framed by the deputy commissioner, and against which there is an appeal and provision. Everything is there. Which is a provision for appeal? Assistant Commissioner.